Your Honour, before the short adjournment, you were asking if there was any Court of Appeal authority or higher authority on the issue of whether or not a judgment was on the merits, I believe.
Well, it was in particular where there is a consent
Yes.
or a judgment on admissions.
Your Honour, I've not been able to find any authority to that effect. There is, however, some Court of Appeal guidance on the phrase on the merits, and that is the case of Charm, Maritime and Kyriakou, which is at tab 12 of the defendant's authorities. Your Honour, yes.
Yes.
Your Honour, that was a case involving issue estoppel, and it involved proceedings between a shipping company and Mr. Kyriakou as in respect of the ownership of shares. The procedural background is quite complicated. There were no less than 6 set of proceedings in Greece before the matter was brought to England, and an application was made for a stay of the proceedings in England. One of the grounds was that because of the issue estoppel, it was an abusive process.
Yes.
So, Your Honour, if I could take it up at page 7 of the judgment.
Yes.
4th paragraph down. Over the years, our law has developed the principles res judicata on 2 grounds. The first being that it is in the public interest there should be an end of litigation. The second being that justice to the individual requires that he should not be vexed twice for the same cause. He then goes on to deal with the Carl Zeiss case. He then recites the words of the Senate, where the highest lord stated that there are 3 requirements which have to be satisfied in order for an issue estoppel. The first is the judgment that any earlier action relied on as creating estoppel must be A court of competent jurisdiction, B, final and conclusive, and C, on the merits. He then deals with Lord Granville's definition of on the merits. And over the page, on page 8, it would appear from the judgment that when Mr. Chadwick opened his case in the court below, he submitted that issue estoppel precluded Charm from raising the 2 new counterclaims which it now seek to raise in the new proceedings, because Charm might have raised but chose not to raise them in the Greek proceedings. In response to this submission, Mr. Hunter, on behalf of Charm, submitted that there could be no issue estoppel because there had been no final decision by the Greek court on the merits, within the meaning of that phrase as explained in the Senate. Mr. Chadwick, in his reply, accepted that the evidence before the judge did not suffice to prove that, in relation to the 2 new contentions, the decision in the Greek proceedings was a final decision on the merits within this meeting, because it was not clear on the evidence that under Greek law, the 2 new contentions could not be pursued in new proceedings in Greece. And then over the page, page 9, from below the quotation, the next 3 paragraphs, I would just draw your attention to.
I'll just look at this myself.
page 10 at the very bottom, above appropriate forum, you will find the conclusion of the judge on the abuse of process argument. This is Lord Justice Slade.
Yes, thank you very much.
So, again, lest there be any doubt, the phrase on the merits has a clear and defined meaning as a matter of English law as applied in this court. And that is the meaning attributed to it by Lord Brandon in the Senate, which is that it is a decision which establishes certain facts, proved or not in dispute, states what are the relevant principles of law applicable to such facts, and expresses a conclusion with regard to the effect of applying those principles to the factual situation concerned. This decision plainly did not comply with those requirements and cannot, as a result, be described as one on the merits. And in our submission, that is sufficient to render it a judgment which isn't susceptible to enforcement or recognition in a foreign court.
Well, imagine this case. A claim is made, and in respect of the particular loss, and the defendant admits liability and admits the quantum, and judgment is given on the admissions. And the claimant then starts fresh action because he's realised that he could have sought further damages for a further loss, he having been in the position to have made such a claim in the first instance. Would he be allowed to bring a fresh claim? Or would it be said that it's re-judicata?
Your Honour, my submission, you should be allowed to bring such a claim because there is no judgment on the merits that's giving rise to an issue of estoppel.
Let's keep our eye on practical justice and common sense. Why on earth should he be allowed to bring such a claim?
Why on earth should he not?
Well, for the two reasons that are given in support of the doctrine of res judicata. There must be finality, and a defendant should know where he stands as far as liability is concerned. Are you suggesting that those two considerations do not apply with equal force to the case I postulated, as they do to a situation where there was in fact a trial on the merits?
Your Honour, the issue of finality is confined to the particular facts in the case. So if there are fresh facts giving rise to additional damages claims, it cannot be said to be final on that claim. And the
One cause of action, claim brought that cause of action for a particular loss, even if it was tried on the merits. Assume first that it was tried on the merits. There can't be another claim brought on the same cause of action for some different loss. I suggest to you that the same law would apply where there had been judgment on addition to the first.
Your Honour, the analogous situation is where the English courts have permitted default judgments to be reopened and litigated on the merits on the basis that the default judgment may not be enforced in a foreign court. Now, that is a specific procedural device that permits the enforcement of the judgment in a foreign court because the default judgment may not be recognised. So similarly, if there was something like that in respect of judgment on admissions, then it would be open to the parties to relitigate the issue.
Well, I suggest to you that the same law would apply where there had been judgment on addition to the first. I suggest to you that the same law would apply where there had been judgment on addition to the first. And I suggest to you that the same law would apply where there had been judgment on addition to the first.
It would be open to the parties to relitigate the issue. Your Honour, there's nothing mechanistic about it where the judgment of the New York court in this case has no description of the merits or of any form of reasoning whatsoever. It is simply a piece of paper that says it is adjudged that, or it is entered into the court system that my clients owe the claimants X amount of money.
Well, we do know that. Let me assure you, because I understand the argument which you're making.
Your Honour, yes.
I'm not confused about how you're putting the argument. I'm testing the argument in the conventional way.
Of course.
And it may be that we've covered the ground. Now, on that regard, if there are any other points you want to make at this stage of your case, well then, please do make.
No, I think you have my points on that. If I can move on then to the issue of a stay. This is not to be confused with an issue of the stay of the immediate judgment application. With the stay of any execution of the immediate judgment were it to be granted. There are two separate stays
Yes.
that Your Honour can grant. One is a stay of the proceedings generally, pending the determination of the New York courts.
Yes.
Another is having determined that this court has jurisdiction and that it should proceed to immediate judgment, a stay of any execution of the immediate judgment.
Yeah.
So I'm now addressing the first stay.
Yes.
And in our submission, it would really be a very risky course for this court to follow to not stay these proceedings pending the decision of the New York court, because the New York court may well decide that it's the judgment before it is another issue. It may well decide to vacate that judgment. In those circumstances, for this court to have proceeded to immediate judgment and to any such mechanism for enforcement of this judgment would be effectively jumping the gun. And we say this court shouldn't do that.
Yeah. Presumably you don't say that this court will not at least embark on a preliminary consideration of the merits.
To the extent that it's necessary to reach a decision, no, we don't. But to the extent that this isn't an immediate judgment application at this stage, and it's only on that application that
Yes.
those issues are properly dealt with,
Yes.
then we say,
I see. So you'll come back to that in response to the
Yes.
immediate judgment
I will.
cases. Yes, well, I follow you. Yes. I'd like a little help on the factual context.
Of course.
As to, but first of all, as to whether the affidavit of confession could only be used not only after the passage of a particular specified date, but could only be used if certain events occur, such as a default on the term agreement.
Your Honour,
And
yes.
secondly, those are really points of law, right? And secondly, on the facts, whether or not the term agreement was tied.
Your Honour, yes. A good starting place might be the term sheet itself.
Yes.
And if I could take you to that, that's in bundle 2A of the hearing bundle. page 299.
I've got the bundle 2A and the 2B. You know which one it is?
2A.
2A. Yes.
299.
Yes, thank
So starting with the first recital, upon execution, this will, in respect of the provisions identified below, be a binding term sheet, this term sheet, describing certain of the material terms of a settlement agreement between Essar Global Fund Limited, certain of EGFL's affiliates and subsidiaries that are signatories hereto to which EGFL owes debts and payables, and the lenders. So there is no doubt that this term sheet is representing the binding terms of the material settlement agreement.
Yes.
It then goes on, terms and provisions of the term sheet designated upon execution of the term sheet, including without limitation sections 3, 6, 7, 9, 10, 16 and 17, and portions of sections 4 and 13, shall be immediately binding and effective upon the parties. All other terms and provisions contemplated by this term sheet are subject to definitive settlement documents to be negotiated and entered into between all relevant parties on or before the 24th of March 2016, provided that the effectiveness of such settlement agreements will be subject to a finalisation of the definitive documentation by 24th of March 2016, and B, EGFL making the first instalment of settlement amount as defined below of US $10 million by the 24th of March 2016. And then you have the recital, upon execution of the term sheet, the lenders undertake to forbear, suspend and hold in abeyance all of their rights, actions or claims of whatever nature, including presenting any winding up or similar petition, and on the confessions of judgment as agreed herein against EGFL or its affiliates until 31st of March 2016, provided that EGFL makes the first instalment of the settlement amount of US $10 million on or by 24th of March 2016. Now, the claimant relies on that recital effectively for its assertion that the term sheet is not conditioned upon any act of default by the defendant before it can file the affidavit of confession and obtain a confession of judgment, a confession judgment. The defendant, on the other hand, points to section 4 of the terms of the term sheet, payment plan, page 301. Upon execution of the term sheet, EGFL and the lenders agree that the settlement amount of US $415.4 million plus interest at a rate of 13.5% per annum, commencing on the date hereof, and any fees and expenses incurred to enforce payment thereof, collectively the settlement amount. Then, a little bit further down the page, the lenders have agreed to accept the settlement amount or the early settlement payment is applicable if paid on the following schedule: the payment plan, US $10 million on or before the 24th of March 2016, and there is then a detailed payment plan, and it then goes on. In no event or action occurs, if no event or action occurs that could subject the settlement amount or early settlement payment to avoidance under applicable law within 180 days after the lender's receipt of the final payment of the full settlement amount or early settlement payment in cash, all lenders' claims against EGFL and its affiliates, including the borrower and holdings, will be passed to EGFL or cancelled in full, and the confessions of judgment provided by EGFL pursuant to section 3 above shall be null and void and shall be promptly returned to EGFL upon EGFL's written request to the lenders. And Section 5, lest there be any doubt that the final payment amount is to be paid under the terms of the payment plan, that provides, if any event or action occurs that could subject the settlement amount or early settlement payment to avoidance under applicable law within 180 days after the lender's receipt of the final payment of the full settlement amount, or if the settlement amount is not paid in full under the terms of the payment plan, the confession of judgment shall be reinstated to US $617 million, less any amounts received by the agent or the lenders that are not subject to avoidance. So the defendant's case is that the confessions of judgment are null and void if it pays the settlement amount. It is only obliged to pay the settlement amount under the terms of the payment plan. So long as it is complying with the payment plan, the claimants have no right to enter the confessions of judgment. And the defendant says that's the only commercially reasonable interpretation that could be put on this document, and any other interpretation would be commercially absurd. Now, it may be, because you will have noticed, Your Honour, that the balance of the settlement amount is payable under the payment plan on or before the 31st of March 2017. And it may simply be that in the first recital that the claimant relies upon, there has been a typographical error, with 2016 being put in for 2017, which would make a lot more sense.
Would you just pause for a moment when I get hold of that? Yes, thank you.
It is difficult to imagine why the defendant would agree to a detailed settlement agreement with detailed payment plan provisions and yet expose itself to having the confession of judgment entered just 8 days after its first payment under the payment plan. So, our case is that the confession of judgment was conditioned on a default under the payment plan, and that default had not taken place.
Yeah.
Now, the judgment was entered with the New York court by an affidavit, pursuant to an affidavit filed by Mr. Feinstein.
Yeah.
Which you will find at bundle 2B. And that affidavit makes no reference to the term sheet whatsoever under which the confessions of judgment were issued, pursuant to which they were expressly said to be given. Indeed, at paragraph 8, where it purports to give credit for the $40 million of payment already made, it is singularly silent as to the payment plan pursuant to which those payments have been made.
Yes. Has
The affidavit of confession itself is that
I'm just reminding myself of that. Where the term sheet is referred to in the cycles. Paragraph 1 of the stipulation is that your client stipulated and agrees that the amount of its liability under the guarantee is so much, and then there's the interest.
Your Honour, yes.
And to confess his judgment.
Your Honour, it's right to say that the affidavit of confession makes no mention of the payment plan either. But
It doesn't make it's a term sheet, not a payment plan within the term sheet.
precisely, and it says it's issued pursuant to the term sheet and contemporaneously with it.
Do you accept that the confession of judgment could be deployed not only if the first installment was made, but if there were any subsequent default under the payment plan?
Your Honour, as a matter of the strict reading of the term sheet, we don't accept that. But I think before yourself in this court, I will concede that it is an acceptable proposition. So that if we were in default of the payment plan, then the confession of judgment could be deployed. Although the memorandum of law filed in New York is to the effect that the term sheet does not permit the filing of the confession of judgment at all unless the final date has expired and it can no longer be declared null and void upon payment of the full settlement amount.
Right, well I see the way you put the legal protections. You've just been over that. That is this confession of judgment agreement. The agreement is on terms. The confession can only be deployed at the end of the state assuming that the first installment was made. I think there's no contest over the fact that the first installment was made.
Your Honour, yes.
Yes, I understand that. Realistically, you accept that there's some flaws in the system as well. If this confession of judgment is not freely deployed at any time, as you say it is, then it could be deployed on breach of the payment plan.
Your Your Honour, yes. If I could then take you to the affidavit, to the statement of Andrew Wright, which is at bundle 1, tab 17. And if Your Honour could have at the same time open tab volume 2A, sorry, 2B of the bundle of documents. So, just to recap, the legal point is essentially that the claimants say there's no requirement for default, we're entitled to file the confession of judgment the minute the 31st of March 2016 is finished, and we say no. They then say, in any case, you were in default, because you were not up to date with the payment plan. And we counter that by saying, no, we paid 50 million, and any delays in our payment, or any mechanism for the payment that was not such that we directly paid it, was agreed by you.
I think they also say that earlier case before the contested last alleged case, there was one or some of those paid late.
Your Honour, yes. And we say that that is really for the subject of oral evidence, because the documents don't clearly disclose the circumstances of those payments, and to the extent that the documents are relevant or do provide any guidance on this issue, they refer to discussions that the parties have been having, and also to an agreement between the parties that the payment could be made by virtue of being paid into an escrow account. So, Mr. Wright is the senior legal counsel for Essar Capital, and he was involved in the negotiations that culminated effectively in the final $10 million payment. Now he sets out from paragraph 14 onwards how these payments were dealt with and what the understanding was in relation to them. And if I could just invite Your Honour to read paragraphs 14, 15, 16, 17, 18, right through to
Yes.
to 22. So Your Honour will see that the first email they're referred to is at page 359 of bundle 2A, 2B.
Yes.
And that is from a gentleman called Ravi Mehta,
Yes.
who works for DK Partners, who are acting for the claimants,
Yes.
to somebody called Joe.
Can we give him a surname?
I'm afraid Joseph Seifert, I believe.
Seifert.
Your Honour, yes.
Right.
And he says, Joe, as you are aware, pursuant to the EGFL settlement term sheet, there was a $10 million payment due to US Bank on the 1st of June. That's the 30th of May payment.
Yes.
Pursuant to our previous discussions, while the payment plan and the term sheet was not amended or modified, the lending syndicate agreed to allow EGFL to make the 1st of June payment in 2 installments of $5 million. The first installment was received as agreed on the 5th of June, and the second installment of $5 million is to be paid on Monday, the 20th of June. So we say that clearly evidences an agreement for the delayed payment of that installment, which was due on the 1st of June.
Yes. Can you give me the date of this email?
Your Honour, I believe it's the 16th of June 2016.
When did that happen?
Your Honour, I don't think the relevant page has found its way into the bundle, but it is stated in Mr. Wright's statement that it was timed at 0021 on the 16th of June 2016.
Yes, I see. Yes. Yes. Hello?
Now, Mr. Mehta in this email goes on to say, we understand that EGFL desires to put $5 million into an escrow account with US Bank on account of the second installment. Please find attached a draft escrow agreement and certain additional documents that US Bank needs to complete in order to sign the escrow agreement. So, over the page, at page 360, you find the escrow agreement.
Yes.
And the significant point about this escrow agreement is clause 4, which is at page 361.
I think it's side B. Anyway, clause 4.
Which essentially provides that the funds should be returned to the depositor, who is plainly acting on behalf of EGFL.
No.
If a participation agreement with a third party, such third party to be acceptable to the agent and the lenders, is entered into on or before the end of the escrow period. So the whole point was either EGFL would pay directly the monies, or they would be paid through the participation agreement. And that is the point of this escrow agreement. The funds are returned to EGFL if a participation agreement is entered into.
Yes. And you say that goes to discharge. The liability is paid the second 5 million under the term sheet.
Well, as it happens, the second 5 million for this particular instalment was not was taken from the escrow agreement. So it wasn't returned to the depositor. It was paid out directly to the claimants on the 15th of July 2016, which was the expiry of the escrow period. But the principle that if there's a participation agreement, we won't be paying directly is established by the escrow agreement.
So the claimant received the second tranche,
It did, because it took it directly from the escrow account on the expiry of the escrow period. So again, we say there can be no issue as to delay in respect of that payment, which was done in accordance with the escrow agreement that is signed by both parties and agreed by them. So that's the 30th of May payment. We then come to the 30th of June payment,
Yes.
which is the final payment before the confession of judgment was
Yes.
filed. Now, although the participation agreement in respect of the first escrow agreement wasn't in place at the time that the escrow period expired, the parties nevertheless continued their negotiations to agree a participation agreement. And that is evident from page 380.
Is the first participation agreement in the bundle?
There was only one participation agreement.
Is that one in the bundle?
That is, yes.
We're going to come on.
Yes. Page 380, somebody from, on behalf of EGFL, writes to Radiometer, re-escrow agreement, 23rd of June 2016. Ravi, what do you propose with regards to the next steps, i.e. participation agreement? I believe your lawyers will be drafting it. When can we expect a draft? And over the page, Mr. Mehta replies, please see quote from Chapman attached. Can you please send the expense deposit as per their email? We will send you a draft shortly thereafter. So the participation agreement, the draft of it has been provided to EGFL, to the defendants, and it's being paid for by them as well, the drafting of it.
Yes.
At page 375, you have the email from the lawyers that was forwarded, which sets out their fees of $60,000 in connection with the escrow agreement and the last act participation agreement for the Essar transaction.
That's also a 10th agreement.
Now, against that background, you get an email at page 385 which is sent on the 26th of June. And this is from Avi Friedman to Prashant Ruia. And it says, does it make sense for us to connect early this week? I want to make sure we're on track for the June 30th payment. This buys EGFL 60 days of relief to work on all the other fronts. There is a meeting at the state tomorrow, and our advice will be there.
What is the this? This buys.
Well, in the context of these email exchanges, our submission is that it could only be the entry into the participation agreement. Because the way the escrow agreement was meant to work with the participation agreement is that either we paid funds into escrow or there was a participation agreement, in which case those funds were returned to us. So he's basically asking us to sort out the second escrow agreement and the participation agreement that will go with that, and saying that will take care of our 30th of June payments, and we will then have another 60 days.
Now, this is just someone
Prashant Ruia is one of the brothers who are the controlling minds of Essar generally.
Well, so this is crossing the line, so to speak. This is the term within the defendant's side of the
No, Avi Friedman is the managing member of DK Capital Management, and he is acting for the claimants.
I beg your pardon.
So he's emailing directly Prashant Ruia, who's very high up in the Essar organisation.
Wait a minute. Thank you. That concludes. Can you give me the surname?
Ruia, R-U-I-A.
Thank you. Right. With you.
Then over the page 386.
Well, perhaps just sorry, if you give the help me with why the participation agreement buys EGFL 60 days relief.
Because it would constitute payment of that instalment, and the next instalment was not
That's
due
all it means. Just
until.
clear that installment and then go on.
Yes.
Yes. This is helpful for me.
Page 386. Again, the defendant, writing to Ravi Mehta, attached is the swift details of the Chapman retainer fee. I hope we can get a copy of the participation agreement sometime today. So the participation agreement is still not been drafted as yet. Page 387, Ravi Mehta to the defendant, copy to Avi Friedman. Thanks, Chapman has received the funds. Please find attached a draft participation agreement we will look at for your comments. Please also find attached a new escrow agreement on account of the upcoming $10 million payment due this Thursday, 30th of June. As I mentioned on Friday, the simplest procedure would be for US Bank to receive the funds into escrow on Thursday, exactly as we did last week. You can see the attached agreement is identical to the last one we signed, except for the date and amount. Can you execute and return tomorrow?
Yes.
We then jump forward to page 394. Where on the 13th of July, the defendants write to the claimants' representatives copying a Jamie Williams at Keystone Group Services. Chapman team, in respect of the proposed participation agreement, we would like to introduce Jamie Williams. Jamie is representing the investors at Skyway and will be leading discussions on their behalf. Jamie is based in Hong Kong and will reach out to you to discuss the way forward on this agreement.
Now, Malia Sotomayor, she is the defendant. Essar Capital Americas.
Your Honour, yes.
Thank you.
There then follows on the same day an email from the claimant's lawyer, Nicholas Whitney, at chapman.com. That's at page 396. Sent to Jamie Williams and copied to Ravi Mehta, Abby Friedman, Malia Sobriwala, and to Andrew Wright himself. And that provides a table for completion by Jamie Williams in respect of the KYC information that was likely to be required by DK lenders.
No, your client.
Yes.
Yes.
Page 398. Abby Friedman, on behalf of the defendant, the claimant, writes to Jamie Williams and Nicholas Whitney, copied to all the other people that we've just discussed. Jamie, I understand that from Essar that you have a participation agreement with minor comments. Please send those through overnight New York time. The Chapman team is ready to discuss, starting at 8 a.m. New York time, and to stay on as long as needed to resolve any open issues.
Yes.
Then at page 401, the following day, you have Abby Friedman again writing directly to Prashant Ruia. Subject participation agreement. This is not a light markup and was received 7 minutes before the call. We are pushing the call an hour to go through it, but there is a lot of red.
Yeah.
Now, at the same time as the participation agreement was being negotiated, there was also a representation agreement being dealt with. And at page 403, you will see from Ravi Mehta to Avi Friedman, various people at Chapman, Benjamin Feinstone, and to Prashant Ruya and Andrew Wright. Andrew, Mary, can you execute this rep today?
That was linked to the participation agreement,
Your Honour, yes. Effectively, the claimant required representation from the defendant that it wasn't capitalising the participant in the participation agreement. So the participation agreement effectively is for $10 million. It represents $10 million of the underlying credit agreement loan. And it is a participation in that loan on the face of it.
What loan is that?
Well, we say that it was agreed by the parties that $10 million paid under the participation agreement would represent the payments that were due from us under the payment plan. And that is the point of these emails.
Yeah, I follow that. Why is it called a loan?
Well, no, the original credit agreement, whereby the Minnesota Steel Company was loaned $415 million, is what the participant is buying into by reason of the participation agreement. So he is effectively discharging a part of that loan by paying $10 million of it to the lenders.
And in the hope of what advantage?
Well, Your Honour, this is a question which the participation agreement does not make clear what the participant will get out of this except repayment of that $10 million at some stage. But what is clear is that it is payable to the lenders. Now, to the extent that the Skyway Funds has not been included as a claimant in these proceedings, and the claim under the guarantee is for the full amount that was lent under the credit agreement, there is something rather odd, because either that amount should be reduced by $10 million, or Skyway Funds should have a right to reclaim that amount. And that is just not addressed in the claimant's evidence at all. It's left as hanging in the air. How is this $10 million accounted for by them? All they say is they don't need to give us credit for it. Going back to the emails, page 404, the draft representation agreement was forwarded to the claimant. And at page 408, dated the 15th of July 2016, which is the date that the escrow period expired under the first escrow agreement. Andrew Wright contacts Ravi Mehta.
This is 2 Andrew Wright. 4
I beg your pardon, at page 406 and 7.
Okay.
He asks, are you in a position to sign the participation agreement today, as recital sheet is drafted? The agreement is to be signed on the same day as the participation agreement, and it makes sense that the two go hand in hand. If that is the case, then EGFL is in a position to sign today, subject to any comments the Millbank team may have, but hopefully none. And at page 408, there is an email from Chapman to Andrew Wright saying that we do not know the exact date of the participation agreement will be executed, but we're anticipating it will be Monday. Rather than having to coordinate on the day the participation agreement is executed, how about if we change the representation letter to delete the date of the participation agreement and refer to the participation agreement as the participation agreement to be entered into by ... At page 409 to 410, Andrew Wright responds, effectively saying, that's fine, but from a practical standpoint, the representation agreement will be meaningless without the participation agreement, because the representation only relates to the participation.
Yes.
Now, the participation agreement was eventually concluded on the 19th of July. And it is at page 419. It doesn't refer expressly to the payment plan or to the fact that it's discharging, that payments under the participation agreement are discharging payments due from EGFL under the payment plan. But hopefully the emails that I've just shown you make that quite plain.
The credit agreement referred to inside there is the credit agreement provided for 105 million.
Your Honour, that's right. And in recital E, you have the term sheet referred to. Pursuant to the term sheet, EGFL agreed, amongst other things, 1, to settle its obligations under a guarantee in favour of the agent for benefit to lenders, and an equity contribution agreement by and among EGFL, the borrower, and the agent, and 2, to make certain payments to the lenders pursuant to a payment plan set forth in the term sheet. At page 427, you have the representations and warranties of the participants, that's Skyway Funds. And subparagraph H, it represents and warrants it as entirely separate and not an affiliate of EGFL. Subparagraph I, it has no agreement or understanding with EGFL related to or in connection with the last night's participation interest. And 2, to its actual knowledge, without duty or inquiry or investigation, that would result in a breach or violation by EGFL to violate any provision of A, EGFL's organisational documents, B, any statute, law, writ, order, rule or regulation of any governmental body applicable to EGFL, any judgment, injunction, decree or determination of any governmental body applicable to EGFL, or D, any contract, indenture, mortgage, loan, agreement, note, lease or other agreement, document or instrument to which it may be a party by which EGFL may be bound, or to which any of its assets are subject. The representation agreement is at page 456 to 460.
Yes.
And again, recital E refers to the term sheet.
Yeah.
And now you have representations and warranties of EGFL. D and E are the relevant representations and warranties at page 457.
Yes.
There are subsequently emails between Jamie Willen and representatives of the claimant regarding the two $5 million payments under the participation agreement. The claimant relies on those emails as showing that the participation agreement was a transaction that was unrelated to the term sheet or to the payment plan under the term sheet. And we say that is to look at the matter very selectively, because those emails are about the actual payment to be made by Skyway funds, whereas the understanding that they were paid to discharge our obligations under the term sheet is plainly evidenced by the emails that I've just taken your honour to. In the event that those two payments were made, I believe, on the 18th of August and the 21st of July.
Does Sideways forego any rights obligation as against your clients in respect of these payments?
Your Honour, there is a section in the participation agreement that deals with subrogation, and that effectively provides that the Skyway subrogates it's section 8, page 426.
Yes.
And that provides effectively that it can't exercise any subrogated rights until the total purchase consideration or the early purchase consideration, as applicable, have been paid in full in cash to the lenders. Your Honour, yes, and it's largely premised on the fact that other lenders of EGFL, the defendants, were getting concerned that it was making payments to the claimants when they may have rights. Precisely. Your Honour, just to complete the story, at page 601, there is a letter from Alpha Bridge Limited, who are the trustees for the Skyway Fund. To the defendants' New York attorneys, which says, we, Alpha Bridge Limited, confirm that we entered into a last act participation agreement dated the 19th of July with US Bank National Association as collection agent in order to make payments to US Bank as coordinated with Essar Global Fund Limited in an amount that was equal to the amount that EGFL was required to pay in June 2016 to US Bank as set out in the term sheet dated 18th of March 2016. Further to this arrangement, we made two payments of US $5 million each, the first on or around 21st of July, the second on or around the 18th of August, in a total of $10 million. US Bank and Midtown Acquisitions were fully aware of and agreed to this arrangement at all material times.
Yes.
So, Your Honour, in our submission, the documents make it very plain that the payments under the participation agreement were effectively payments under the payment plan by the defendant, or were to represent the 30th of June payments. And that is what everyone understood. And that is what these emails and these documents make plain. If that is right, and we say that it's plainly arguable on these documents, and certainly not a matter that can be decided on an immediate judgment basis by this court, and you would need to hear evidence from the writers of these emails, from the New York attorneys as to the New York law that is involved, and so on. But if that is right, then we were up to date with the payment plan at the date that the confession of judgment was filed, and there was no right to file it. And it's on that basis that we have made the motions to vacation New York.
So will all this material that you've shown, together with the intentions you made, be part of your application in New York on both notices and motions?
Your Honour, yes. It will, and it will be a central issue. In New York, there are essentially two issues. One is, were the claimants entitled to enter the confession of judgment absent any default on our part? And that is an issue of the interpretation of the term sheet. The second is, if they were not, were we in default in any event? And they say we were, because we weren't up to date with payments, but we say that the agreement was that the payments would be made in the form that they were made, and they say we were because we don't pay 40 million as opposed to the 50 million.
And the motion will be on the basis of affidavit evidence.
Your Honour, as I understand it, oral evidence will be heard at that motion, and that is the subject of one of our witness statements. Well, one of our witnesses says that without waiving privilege, he is advised by his New York attorneys that they will require oral evidence to determine this issue in New York.
All right, well, thank you very much. Well, I think that concludes your opening submissions.
Well, that is the factual background. I'm quite happy to wait to make my submissions on the immediate judgment application.
Yes, if you wouldn't mind, because I think they could make it short.
Your Honour, yes. Your Honour has in mind the broad merits of the situation that we're in, and this was perhaps a lesson in how even in what one would hope would be one of the clearest of cases, defaulting parties will find something to hang on to in resisting enforcement. On the face of it, Your Honour has a judgment entered by consent, it's agreed that it should be enforceable, and it is now agreed that there is currently a liability, and that by the end of next month there will be a very significant liability in excess of the size of the judgment. I'll just remind you, Your Honour, that even under the payment plan, $100 million is outstanding, and even on and on my case, they say 110 million, and that depends on the Skyway payments. And then by the end of next month, the defendant has to come up with, in total, payments of $415 million. So on my case, that is 375 million more that they need to produce, and on my learned friend's case, 365 million. So that sort of thing, factor, I say, colours the way that Your Honour approaches the case, but also will be relevant to the question of stays at the end of the case, because the purpose of the stay is to protect, if there is to be one, is to protect the defendant from the risk that the defendant has to pay money, but then doesn't get the money back when there's to be an accounting at the end of it. And if everybody agrees that at the end of that accounting there's no prospect of money ever going back, then that's got to be a very relevant factor in the question of whether there's to be any stay at all, and if there is, on what terms. In my case is that this is an attempt at each stage to slow down the payment of what is in effect an amount which is undisputed, or at least will be undisputed by the end of next month. And really this is an argument about whether or not this is the right method by which my client can collect the payment of those sums. So is it right that we can go to your court, get this sort of judgment and enforce this sort of judgment in the DIFC and then use the conduit jurisdiction to enforce against assets in Dubai? Or should we be doing it in some other way? It's about the method of collecting payment, not really about the question of whether there is or will be very shortly any liability. And the other aspect of that is simply that on my learned friend's case, there would be no defence to my client presenting a confession judgment tomorrow in the New York court. It withdrew its claim today, accepted that the motion was wrong, submitted further claim on the affidavit of judgment, could get that judgment tomorrow, and then we'd be back here again in a week. So those are the if I can put it, the commercial realities of what the positions are between the parties, and that is the reason why Your Honour is dealing, at least in the first half of my learned friend's submissions, with really very technical responses to what is a good claim. It's just arguments about the way in which that claim is being presented, in effect. Your Honour, that's all I want to say by way of preliminary remark. Your Honour did ask us to remind Your Honour about the confidentiality of certain documents. And so simply the participation agreement and the representation agreement. And the only basis on which that is asked is simply that there are third parties who are parties to that transaction, the Skyway Fund. So those documents have been filed under seal in New York. And so the confidentiality of them has in effect been accepted by everybody, including the New York court. So in order simply to preserve that, it's just a matter of ensuring that insofar as we refer to it in open court, that the transcript of the video be redacted, we'll try not to do that in a way which exposes any aspects of the confidentiality beyond what was done. And in the judgment, it may be necessary to redact aspects of the judgment if Your Honour is happy. Precisely, yes. I would hope that it would be a very, very light touch to the judgment and won't affect in any way the principles of open justice. I'm very grateful. So Your Honour, on jurisdiction, on the first part, we do have, well, my learned friend said in his opening, well, I've got two arguments on jurisdiction, constitutionality, and then this question of final and conclusive on the merits. However, as he developed the argument, and it appears in his skeleton as well, as he developed the argument, he did raise a further point, and that is that actually, in effect, it undermines it's inconsistent with his constitutionality argument. He says, in fact, under the relevant DIFC legislation, there just isn't any jurisdiction at all. DNB Bank is wrong. So, in fact, there are three arms. That is a separate part of his case, but all of that is focused on the submission that this court has no jurisdiction, and it's in the context of that submission that he makes his constitutionality arguments to say, well, even if it's right that on that legislation, applying that legislation, court law, judicial authority law, Your Honour has jurisdiction, he says, well, actually, you should refer. So it's a sub-point directed at his main point, which is that this court does not have jurisdiction to do what my clients are asking us to do. And so it's really for that reason that I've said at the outset, well, that is all very interesting, these are all very interesting points, even if somebody else might be, and I'll explain why I disagree with the constitutionality argument in a moment, but even if it was right, that is a matter for the Court of Appeal. I know a friend will need to persuade the Court of Appeal that he has come up with an argument which is good enough to satisfy the real prospects of success required to get permission to appeal. He's going to have to present that argument to the Court of Appeal. Because if Your Honour was to find that there is an issue of constitutionality, or indeed send one off to the Supreme Court, then even that finding would be inconsistent, I say, with the our Court of Appeal's decision that there is jurisdiction. It's not a point that on its terms was raised under the Court of Appeal of the DNB, but it's inconsistent with the conclusion. And so it is inconsistent with the conclusion in DNB and therefore not open to this court. As to the, and obviously that point is even more clear in respect of those additional points that my learned friend raised, attacking specifically the judgment in DNB, where he criticises the specific elements of the DNB. I'll deal with them briefly, if I may, but clearly there's a very recent decision in this by the Court of Appeal. It's not appropriate, I would suggest, for this court to go behind those findings. And even if it were, and my learned friend says, well, it's not binding authority because the respondent to that appeal in DNB dropped their jurisdiction appeal. Well, that's right, they did very shortly before the hearing, but the points were fully argued and the Court of Appeal dealt with it, and they're perfectly entitled. This court, at any point, can consider its own jurisdiction, particularly appropriate in circumstances where its jurisdiction is created by statute. There's no question of submission to this court.
So did the court hear argument?
Yeah, well, it receives argument on jurisdiction.
The argument was covered
in the written materials, yes. Yes.
On that point, no oral argument because it was being abandoned by the time.
Yes, I think that's correct. That's a fair, yes, correct. But so some of the points that were raised by my learned friend, for example, he attacks on the basis that, well, in certain aspects of the skeleton, he says they should have considered a case called Linson, for example. In fact, Linson is not authority and has been disapproved. But in any event, that specific case was raised. The points about recognised foreign court that you've heard, Your Honour's heard today, those points were raised, and you could see reflections of them in the judgment. But even if I'm wrong about the binding nature of DNB on those issues, you also have the first instance decisions in both DNB and the Bosmar case, which then Deputy Chief Justice Sir John Chadwick decided enforcing foreign judgments. And indeed, in both of those cases, by the way, this court was enforcing default judgments. So unless my learned friend can show that those judgments are plainly wrong, then the convention would be that this court would follow them on that issue in any event. So, Your Honour, and then the final point, obviously, is this question of whether or not the nature of the judgment. Is it a judgment? Is it final and inclusive? Is it a merits? Which box does that go in? On one level, Your Honour's absolutely right. It doesn't make much difference. The court's got to grapple with it. Technically, it might make a difference, simply because on the jurisdiction application, the question is my learned friend right or wrong? On the immediate judgment application, the question is, does my learned friend have a real prospect of success? So the test is slightly different, but also the outcome of this case, of this hearing, could only be on the immediate judgment application that my application is dismissed, not that my claim is fair. Does that make sense? Your Honour, then, I'll turn then, if I may, to the constitutionality argument. So, just to recap the argument is then that Article 120 of the Constitution reserves matters of foreign affairs, enforcement of foreign judgments is a matter of foreign affairs, and therefore the Dubai government has no power to legislate for the enforcement of foreign judgments. And Your Honour asked about Act Clare. Your Honour was also taken to the case of Fiscus Thurman. And what that does is it addresses, at first instance in this court, the test, the threshold. What does my learned friend have to establish? What threshold does he have to meet to justify a referral from this court? Is it just an arguable position, or does he have to show something more?
Well, I think he accepted that it was the threshold was a necessary but not sufficient requirement. So that even if the level of arguability was established, it doesn't follow that the court is obliged to make a reference.
Yes, I heard that concession as well. And that still asks the question, begs the question, well, in what circumstances should this court refer? So what we have in the DIFC, we have 3 decisions on this sort of issue. We have the Fiscus Thurman case, and that is the case in which His Honour Judge Ali Al-Madani directly asked the question, what is the threshold? In what circumstances should I refer? And his response was that the party seeking the referral needed to establish the unconstitutionality, and he put it to the same level as would be required in front of the Union Supreme Court. And so my submission on that passage was simply that what we have there is, at first instance, yes, but we have a judge who had access to the relevant Union Supreme Court authority. We don't have that today. Making a decision to the effect that on the merit, he said in terms, the court needs to look at the merits, and then the court needs to be satisfied to the same level as the Union Supreme Court would be. So in other words, I need to agree with you, with the defendant, that this is a piece of legislation which is unconstitutional. That's the effect of what he said.
Well,
in principle,
he was simply looking at it from a review of the pleadings. Is there enough here, without any final determination by me, for this to be a fit matter to go before?
well, I think it's difficult to reach that interpretation of what he's saying. In my submission, that is another view of where the threshold might be. I won't take you on back to the case, but as I say, what one has there is an Arabic-speaking judge, an Arabic-reading judge, who had the benefit of the Union Supreme Court cases. Your Honour has the reference to that position. If Your Honour thinks that that is clearly wrong, Your Honour will depart from that as a decision. But if one actually looks at the text of what Justice Ali Al-Madani said, he said you have to look at the merits, and then you have to be convinced to the same level as the Union Supreme Court. And the only decision the Union Supreme Court is making is yes or no, it's unconstitutional or not. So the only way one can interpret the same level as is meaning that you have to get this court to the same place you have to get the Union Supreme Court, which is agreeing with you. So that, in my submission, is clearly what he was saying. Now, Your Honour may disagree, and Your Honour's not bound by it, but that is his position. In practice, the way that the court has looked at these issues is simply to dive straight into them and decide them. And that was the way that Your Honour, I believe, was on the IGPL and Standard Chartered Bank case. That was the way the Court of Appeal dealt with the submission of unconstitutionality in that case. It didn't say, it gave permission to appeal on that case, So found that there was a real prospect of success, but then didn't make a referral. So it's not sufficient to say that there's some argument to be had here. And it's important to, otherwise this just becomes a button that the party can press to buy themselves 18 months or however long it takes to go off to the Union Supreme Court, where you have a judgment debt and other parties circulating to collect their money is obviously of great benefit to defendants, but real frustration and to the justice system.
Yeah.
So I say, well, whatever the threshold, my learned friend doesn't meet that threshold, and I say that for two principal reasons. Number one, the enforcement of foreign judgments is not a matter of foreign affairs. It doesn't come within Article 120. But number two, which is barely touched on by my learned friend, even if it does fall within Article 120, the Federation has disapplied civil and commercial laws in the DIFC and has conferred onto the Dubai government, just like other emirates, the power to enact relevant legislation within the special free zones, including the DIFC. So those are the two parts of my submission. Now, on foreign affairs, it seems to me that the answer to my learned friend's position is really quite simple. He makes the point that treaties concern foreign affairs. Then he says, well, treaties usually deal with the enforcement of foreign judgments, and therefore the enforcement of foreign judgments is a matter of foreign affairs. And what that does is it confuses the fact of the treaty, on the one hand, in the creation of which is a matter of foreign affairs, with the context of the treaty. What is the treaty dealing with? We can have a treaty that deals with all kinds of different things. It might be treaties that deal with the way in which countries should apply each other's laws. And we have those in, for example, Rome Treaty in England. So yes, there is a treaty which deals with choice of conflicts of laws, choice of law and contracts. That doesn't mean that choice of law and contracts is a matter of foreign affairs. The mere fact that this is often recorded in a treaty doesn't mean that it's foreign affairs. So that doesn't, in my submission, assist, in particular because it's not always the position, as we know, that there is a treaty in every case where a judgment is being sought to be enforced. And that's true both in this court, we do it in common law if there's no treaty. If there is a treaty, then the DIFC follows the terms of that treaty. That was Article 24.2. But we do it in common law. And Your Honour has seen under Article 235, I think, of the Civil Procedure Code. Perhaps I should take Your Honour to that now, very briefly, to show you how it's done in the common law. And so it's my authorities bundle. The first one is tab 15, please. And it's Article 235. So, Article 235 sets out the circumstances in which the courts under the Civil Procedures Code will enforce foreign judgments. Do you want to have that?
Yes.
An order may be made for enforcement in the UAE of judgments and orders made in a foreign country on the same conditions laid down in the law of that country for the execution of judgments and orders issued in the UAE. And then it sets out the requirements. And those are set out, what's this? Paragraph 2, an order for execution shall be applied for before the court of first instance within the jurisdiction which it is sought to enforce, under the usual procedures for bringing a claim, and the execution order may not be made until after the following matters have been verified, and then sets out the conditions. Article 236 then deals with arbitration awards. So this is the basis for the enforcement of arbitration awards outside the New York Convention in foreign awards anyway. The provisions of the foregoing articles shall apply to the awards of arbitrators made in a foreign country. The award of the arbitrators must be made on an issue which is arbitrable under UA law and so on. And then if that's correct, and that's allowed for in Article 238. So the rules laid down in the foregoing articles shall be without prejudice to the provisions of conventions between the UA and other countries in this regard. So,
where you're not offering the convention, then you have to be within 236.
and therefore within 2. Yes, quite. And so, but the same for judgments as well. So where there's a judgment, where there's the Riyadh Convention, where there's the GCC Convention in place, you follow the terms of the convention. So 235 only applies where there's no treaty. Now, my learned friend produces no authority for the proposition that, as a matter of UA law, enforcement of foreign judgments is a matter of foreign affairs. There's no case that can assist on that. What we do have is some degree of expansion on the topic in the Constitution itself, and see what is being referred to as foreign affairs within the Constitution. If we turn back in the same bundle to tab 13, and so Article 120 is the one that we're concerned with, and then that includes, as we know, foreign affairs, and then Article 123, which says, notwithstanding Article 120, Clause 1, which provides that UA has exclusive jurisdiction in matters of foreign policy and international relations. So, within its own body, the Constitution is interpreting the relevant provision of the Constitution as meaning foreign policy and international relations. That's what foreign affairs is meant to mean. So what the burden on my learned friend is now greater. He needs to establish that the enforcement of foreign judgments is a matter of foreign policy and international relations. And then says the things that Emirate states may do by themselves. A member emirate of the UA may conclude limited conventions of a local and administrative nature with the neighbouring countries, provided that such conventions are not to conflict with the interests of the UA or the federal laws, and that the Federal Supreme Council be notified in advance, and then so on. So, and then an emirate may retain its membership in or join the OPEC organisation and the Organisation of Arab Petroleum Exporting Countries. So what I say is that illustrates the position that when the Constitution is talking about foreign affairs, it's talking about relationships between states, membership of organisations, and negotiations of agreements between the states. What we also have in the bundle at tab 17 is a Cabinet resolution on the organisation of the Ministry of Foreign Affairs. I claim no credit for finding this. This was actually in my learned friend's earlier skeleton, although he doesn't rely on it today. But what it does is it sets out the scope of the duties of the Ministry of Foreign Affairs. And it gives a list of things that ministry does, which one would anticipate are the kinds of things that will be understood as being foreign affairs. And I'm not sure that there's a great deal of help you can get from actually engaging in the detail of that, other than to know that it doesn't say anything about judgments. Now, in my learned friend's skeleton argument, and he dealt with it obliquely, but I'll take you into it because it's helpful to see where my learned friend's argument goes. He makes some points about service of documents at paragraph 10 on page 4, and then paragraph 12. I hope that they're the same. I would hope so. Is that correct? Yes, I'm getting nodding from behind. I think what's happened is that my solicitors have sought to add the skeletons to the bundle. So if Your Honour's already had one, yes. So I think we can dispense with that. Yes. Yes. So it's simply helpful because it shows, I think, how difficult the case is to establish, and the lengths that my own friends could go to get himself where he wants to go. What he says, in effect, is in page 4. He makes points about service of documents, and then he makes the point that service out should be generally through judicial channels, and that is accessed by approaching the Ministry of Foreign Affairs. And so what he says at paragraph 12 is this: it is evident from the guidance referred to above, that the service of process is effected either in accordance with the treaty or by the Ministry of Foreign Affairs via available diplomatic channels. Thus, the service of process abroad is clearly a matter of foreign affairs, which necessitates the involvement of the Ministry of Foreign Affairs. So, just pausing there, I mean, presumably all of the court rules for service out of the jurisdiction, for example, are also unconstitutional. Well, the rule simply says you can serve out if you want to, as long as you do so in accordance with the local rules. That's quite right. That's right. Yes, quite. But legislating for that, making that decision in the rules, rather than requiring some other aspect of it, would presumably be unconstitutional, my learned friends argue. And he says, insofar as service of process is the foundation for jurisdiction, supposing that it isn't in this court, foundation of jurisdiction is statutory here, but in any event, he says, insofar as service of process is the foundation for jurisdiction, which is the foundation for a judgment, there is no reason why matters of service of process should be treated as matters, should not presumably be treated as matters of foreign affairs, matters of recognition and enforcement of foreign judgments not also be so treated. So the argument is service out is a matter of foreign affairs, therefore, and service is the foundation of all judgments, and therefore all foreign judgments, the enforcement of them, is a matter of foreign affairs. And so, presumably, the conclusion, the end state of that, ultimately, is that any case involving a foreign defendant, at least, but possibly a foreign claimant, but certainly a foreign defendant, must also be a matter of foreign affairs, on the logic of my learned friend's argument. Yes, that's true. But much of my learned friend's argument is aimed at showing that enforcement under the provision of the CFC that I've shown you on, the Article 235 provision, is a matter of foreign affairs. Much of what he says, and his written argument anyway, is aimed at that. And I say two things to that. Firstly, it can't be right that that is in fact the position. Even under the civil law, it can't be right that enforcement of foreign judgments is considered to be a matter of foreign affairs. But in any event, that is not the question, because what this court is dealing with on this application is whether or not what this court does in enforcing foreign judgments, and therefore the legislation which permits that process, whether that process is a matter of foreign affairs. Because that is what, according to DMV, according to the authorities, this court has legislated for. So if there's any problem with the legislation, it has to be a problem with the common law approach, because that is what is meant by the legislation, as we know. But just dealing with the first question, even on my learned friend's case, you've got to look at what is meant by enforcement of foreign judgments in the federal courts or in the Dubai courts. It's got to be recalled that the Dubai courts themselves are separate from the federal system. They are not part of the federal judiciary. And that has a number of consequences. It means that the judicial acts involved in enforcing foreign judgments are being performed not by federal judges, but by Dubai-appointed judges who answer to the ruler. So that is problematic for my learned friend. But the other side effect of all of this is that, in fact, the Civil Procedure Code itself only applies in Dubai as a result of Dubai law. I'll show that to you, Your Honour. We were in the relevant tab. I think it's tab. Well, I'll take you first to tab 16. I'll show you, Your Honour, the Dubai law which implements the Civil Procedures Code. It's a very short law. We only have it in translation, happily, but it's in tab 16. And this is, in fact, again, not the product of my research. It was one that was pointed out to me by Justice Ali Al-Adani during the Fisk Firmin case. It's in my authorities bundle, so claimant's authorities bundle, tab 16. Certainly. Yeah, we've managed to outdo ourselves, I'm afraid, with the volume of authority, for which I apologise. Yes, that's right. 16.
Yes.
So what we have here is Dubai law number 5. So it's a Dubai law made by His Highness the Ruler of Dubai for enforcing Federal Law 11 of 1992 concerning the civil procedures before the courts in the Emirate of Dubai. So Federal Law 11 of 1992 is the Civil Procedures Code. I'll take you on to it in a moment. And what this does is it simply says Article 1 gives it a name, and Article 2, Federal Law number 11 of 1992 regarding civil procedure in the Dubai courts shall be implemented. And the reason it needs to do that, we find it's a little obscure from the language, but we find it in the Civil Procedure Code itself, behind the previous tab, tab 15, and it's Article 1. Is that the CPC, the federal law, doesn't apply where an emirate doesn't subscribe to the federal court system. Yes. So the point that I'm making is that the rules for enforcing judgments in the Dubai courts, for example, they come from the Civil Procedures Code. My learned friend's position is, well, that's all right, because it's a federal piece of legislation. So it can legislate for things like that. The point I'm making is that, in fact, that legislation doesn't apply in Dubai unless the Dubai government says so. So the implementation of that legislation is a matter of Dubai law. So what the ruler has done in implementing that legislation is, amongst other things, introduced the bits of the CPC that deal with the enforcement of foreign judgments. So just as he has in Dubai, in DIFC, the ruler has himself legislated for the enforcement of foreign judgments outside Dubai, outside the DIFC in the Dubai courts. That's the effect of these provisions. And my short point on this is that if it's unconstitutional for the ruler to implement legislation for enforcement of judgments here, it must also be unconstitutional for him to have done so in Dubai. So the arguments of my learned friend that this is all a matter of foreign affairs, those arguments lead inevitably, I say, to the conclusion that the Dubai courts themselves have a problem. They can't enforce foreign judgments either, because at least the relevant part of the Civil Procedures Code is also unconstitutional.
In the Dubai courts, is enforcement restricted to where there is a reciprocal treaty?
No, Your Honour, they do apply this provision.
But if there's no reciprocal treaty,
Yes.
the Dubai courts still, under the civil procedure, can enforce.
They can, yes.
Well, that's on your argument, it's a key point.
Yes. Well, yes. I mean that yes. Yes. I think it also applies in relation to treaty-based enforcement as well, because I showed Your Honour the provision which requires the courts to implement, in effect, it implements any treaties out there for the enforcement of foreign judgments. And so that as well would be legislating for matters of foreign affairs. And therefore that too would be problematic, it seems to me. With my learned friend's position, and it all gets quite broad, the way the argument is put, the benefit of the community of nations and principles of that sort, all of those arguments apply with greater force, if they apply at all, to the enforcement of arbitration awards as well. Because if the point is made that, well, enforcement of foreign judgments is almost always put in a treaty, so it's really about the relationships between nations. Well, the enforcement of foreign arbitration awards only comes from treaties. So it's only enforcement of foreign arbitration awards in as I understand. Well, that might be right. Yes, under Article 235, that would be correct. Yes. Yes. You're absolutely right. You're absolutely right. Yes, you're absolutely right. But nevertheless, the point stands that it's certainly no less associated with the kinds of factors my learned friend relies on, which direct this court to find that enforcing foreign judgments is a matter of foreign affairs. But it's so as a matter. Testing now.
You had a very distinguishable view. You had Lord Justice Slade, you had Lord Justice Master. I forget who the third one was, but this is a most distinguished court, and they said that the reason why the obligations of force have ultimately been found in the comity of nations, in other words, respect
Yes.
one court has for another.
Yes.
And if there are proper grounds for that, well then the judgment of the foreign court will be enforced. If there are not proper grounds for it, because there wasn't proper jurisdiction and the other requirements that they have, well then it won't be.
Yes.
It is ultimately put on a common.
Yes, but on a very narrow interpretation of what comity means in that context. And in fact, Your Honour was taken to a passage in particular from the Adams case, the Adams case. And I can take Your Honour back to it, but I'll just... I'm grateful. So what Lord Justice Slade said in the run-up to the bit that Your Honour was directed to was, this cannot be comity on an individual nation-to-nation basis. So the question is, when we're dealing with enforcement of common law, and moved on to the next bit, I was dragged, pulled me forward into that, but and rightly so, is that my learned friends saying, well, underpinning all of this is some sense of respect for other nations. Is that sufficient to make this all about foreign affairs? And the answer is well, no, because what that is talking about, what foreign affairs is dealing with, is nation-to-nation relations, which was precisely the distinction that Lord Justice Slade was careful.
There are a number of principles within the common which reflect very broad notions of international competence. It's not surprising that one national court might take the view that it's right and proper to show respect for judgments of another court. And so there is a common law principle that respect should be shown
Absolutely. And Your Honour made a very good point about forum non-convenience in that context. How can it be that this court can deal with forum non-convenience and make a decision on that if the foreign affairs is so broadly defined? The answer that came back was, well, that's an incident of the common law, so it doesn't come from any statute, and this is what we're dealing with here is legislation. There are two problems with that. The first being, well, this is a court whose jurisdiction is defined, whose powers are defined only by statute. And so yes, it's right that there is no statute which says the words forum non-convenience, just as there is no statute which clearly says the words this court has the jurisdiction to do precisely what I'm asking it to do. The point is that if it must be somewhere, it must be implicit, and it must flow from a piece of legislation which, to that extent, must, on my learned friend's argument, be unconstitutional. But there are specific provisions in the judicial authority law as well, which do require, which for example, state that this court shall not decide a matter which has previously been decided by another court. And that is written into Article 583, the judicial authority law which establishes this court. That it also states that this court may refuse to hear an action if the parties have agreed that it should be heard by another court. So those are expressly written into the judicial authority law. All of that would fall away if my learned friend was right. So he may really trying to get quite deeply into the underpinning of the legislation here. And actually it gets worse when we look at the second part of my argument, which is, well, assume I'm wrong. Assume that the federal law does consider the enforcement of foreign judgments to be a matter of foreign affairs. As I say, that must entail, certainly this court can't enforce foreign judgments at all. So now we're going to be a haven for money, presumably. It may have some benefits, but it's not a very good way to deal with your foreign relations, certainly. But it will also have consequences for the courts outside that sort of conclusion, because it would mean, as I've said, that they can't enforce foreign judgments either. But even if it's right that in the DIFC, enforcing foreign judgments is a matter of foreign affairs, then there's this point that there's a carve-out for the DIFC. And I'll just make that good as fast as I can, if I may. Tab 13 is the Constitution. Article 121. So we've had Article 120, UA has exclusive legislative and executive jurisdiction in the following matters. We then go on to Article 121. Without prejudice to the provisions of the preceding article, the UA has exclusive legislative jurisdiction in the following matters. And I won't read them all, but just to give your Honour a flavour of these. Labour relations, ownership of real property, banks, insurance, major legislation relating to civil and commercial codes, company law, civil and criminal procedure codes, and then right at the end of that paragraph, and regulation of the free financial zones, the manner in which they are established, and how far they are excluded from scope and application of federal legislative provisions. And then we have, behind tab 18, Federal Law number 8, and in Article 3, subparagraph 2, further, these zones and financial activities are subject to all provisions of federal law with the exception of the federal civil and commercial laws. And then down at the bottom, Article 7.3, subject to the provisions of Article 3, for the purpose of establishing a financial free zone, the relevant emirate may issue regulations necessary for it to perform its activity.
Sorry, could you give me that definition again?
Yes. So that was 7.3. So Article 3.2, this applies all civil and commercial laws. 7.3 permits the execution of any, well, they call them regulations, necessary for it to perform its duty. And that's necessary, obviously, because otherwise there would be there'd be a hole. And so much of this has been covered first in this firm, but then again in the IGPL case. And I'll show you, Your Honour, some very short passages from that on tab 7. Oh, sorry, tab 7, page 28, paragraph 94. It's just the bit at the bottom of 94. So recites the provisions that I've just dealt with, and then says two conclusions flow from this. Not at all. It's the end of, it's past the end of the day, I suspect. Page 28. And it's about 5 lines from the bottom. Two conclusions flow from this. So he's dealt with the legislation. As the Chief Justice says, first, the UAE free zone's exemption from the CPC in its entirety is consistent with and sanctioned by the UAE's legislation. Second, far from subverting public goals pursued by the state, the exemption is an essential aspect of the state's economic policy, as implemented by statute. Accordingly, even on the widest understanding of public order, it cannot be said that the DI's exemption from the CPC is contrary to public order. Then we go forward to 97. Accordingly, IGPL's submission and that's fiscally confirming, is incorrect. His decision is consistent with 3.2 of the federal law, which is the one I've shown you on just now, which provides that the commercial laws shall not apply in free zones. Additionally, pursuant to 7.3, power was transferred from the federal government to the individual emirates to issue the necessary legislation for the conduct of the free zones activities within the limits and goals established in the free zones. Accordingly, the Emirate of Dubai was expressly empowered to pass legislation for the conduct of DIFC and manage to allow the DIFC to derogate from UAE civil and commercial laws, which includes the CPC. So the argument today is not that there's a conflict, that was the position in IGPL. The argument today appears to be that the relevant provisions of the CPC, 235 and so on, have been disapplied here, and nothing's been, well, there was no power to fill that gap. That was the case about jurisdiction, so Article 31 of the Civil Procedures Code, and whether or not this court's rules could override or change or alter the jurisdiction arrangements in the CPC. So it wasn't on judgments, but I'll show you on this issue on just one more case, if I may, which is actually very close to this point, and then I'll be done, I think, on this issue. If I can take you on to tab 4, which is another decision in the DME case. This came after the Court of Appeal's decision. So the argument in this case was that this was another conflict case, it was another constitutionality complaint, and what was being said there was that the DIFC court couldn't enforce foreign judgments because the DIFC legislation, which allowed for it, conflicted with Article 235 of the Civil Procedures Code. Article 235 of the Civil Procedures Code was mandatory and had to remain and couldn't be overridden. So that was the position, and therefore there should be a reference. This is the other decision in which a reference has been considered. Very briefly then, paragraphs 10 to 11, Your Honour can see the argument. If I let Your Honour read that, is that helpful? Rather than reading it out. And so the judge's conclusion is 2 paragraphs, paragraphs 22 and 23, where he just says this is more of the same. So he's saying expressly, even if the IGPL case hadn't covered it, that Article 235 and the enforcement of foreign judgments falls within the civil and commercial laws which have been disapplied, and therefore, in respect of which the governments have been empowered to implement legislation. So that must apply here, it applies in the Abu Dhabi global markets as well. They would have the same problem, presumably. And that's the reason why, even if this was a matter of foreign affairs, it wouldn't create an issue. My learned friend says, well, the problem, that's not the answer, because the proviso comes in Article 121. The proviso says that the Federation can legislate for which laws don't apply. That only comes in Article 121. It's not qualified. And in any event, if one looks at the list of things which are reserved to the Union in Article 120, it can't be right that the DIF, there's no power to legislate for that sort of thing in the DIFC. The list is just too broad. So there's just no answer to that argument at all. But I would urge you to prefer the former position, because if that is not right, the former point being that it's just not foreign affairs at all. Because if that's not right, then in effect this court will be saying that what happens in the Dubai courts is unconstitutional, or could be unconstitutional in some way, and that I suspect will not be helpful. So the effect of my learned friend's argument is that DMB was wrong, Bosma wrong, this other judgment in DMB is wrong. This court has been wrong about all of the memoranda of guidance. And the DIFC has now entered into memoranda of guidance with mutual enforcement of judgments with China, Korea, Kazakhstan, New York, Singapore, Kenya, Australia, New South Wales and England. So his position is everyone's just missed this point. But as we see the consequences go further, it's not just the DIFC, it's the Abu Dhabi Global Markets, it's the Dubai courts as well, it's the other emirates that have judiciary independence of the federal system, of which Dubai is not the only one.
I don't know. Do you do that regarding onshore courts?
I believe they have recently done that.
How to enforce foreign judgment?
On the onshore courts, I don't know. I assume that they do the same as Dubai, which is implement the CTC, and therefore they've done it themselves, and therefore it's unconstitutional. I assume so. I don't know the answer. I don't know. Your Honour, I don't know to what extent you want me to address the specific points that are made about the DNB Bank judgment. There are specific criticisms that are made. I'm grateful.
So I think you can take it, but I will take on board what said in those
I'm grateful for it. The point to take away from my learned friend's submissions on that is that at one stage in his submissions, when he was dealing with this question of whether Article 7.6 confers jurisdiction to enforce judgments, Your Honour made the point, which was my point in DNB, that if this court can execute, surely it can enforce. It must be implicit in that it can do that. I think my learned friend effectively conceded that, which to my mind is the end of the argument, regardless of any other points. If this court, and just stepping back from it, we have legislation which permits it.
And maybe applying that, the answer follows.
Your Honour, towards the end of my learned friend's skeleton, he deals with this in response to the immediate judgment application, but it's normally a point that is raised by defendants, if I can put it like that, at the jurisdiction phase, in that it comes before any questions on the merits of the claim. He does make points about there are no assets in this jurisdiction. He makes points about abuse of process. He says this is more likely to be an abuse because my clients are pursuing enforcement in multiple jurisdictions and so forth. You've got my submissions on that. The only point that I would just highlight on all of that is simply that my learned friend relies on a case called Linson. Linson was a decision on permission to appeal in the English courts, and it was a decision which was made without reference to Fono and Demerol, which was the leading case on the question of service out when we're dealing with enforcement of foreign judgments. Fono and Demerol says, under the English system, to get permission to serve out, you need to show legitimate benefit from enforcing the judgment in England. And what Linson was not, that judgment wasn't cited in obtaining permission on Linson. And so in Linson, the Court of Appeal reduced that to saying you have to show that there are assets in the jurisdiction. That Linson case has subsequently been considered by the English courts in a case called Habib Bank. It's in my skeleton argument. And in express terms, the judge there, Mr. Justice Burton, said, A, Linson's not authority for anything because it's a decision on permission, and B, is wrong. So I just bring that to your attention to ensure that that doesn't lead to a dead end. So those are really the only jurisdiction points in my submission. Your Honour knows I appeared before you in the case of Protivity and tried to persuade Your Honour that when deciding issues of jurisdiction there must be some threshold on the case, as there would be in England when obtaining service out. Your Honour found firmly against me on that. What matters is the shape of my case, not what supports it. The shape of my case is this is a claim to enforce foreign judgments. That's the end of it. Just like in England, that's all you have to show to establish jurisdiction. This is a claim to enforce foreign judgments. They're going to run the point in England and suspect it will meet the same response.
There is an element of service involved in
An element of, sorry, service.
There has to be service of proceedings for proceedings to begin. And in England, where that service is effected within the jurisdiction, then that's it.
Yes.
I mean, keeping out of the European.
Yes.
And where, under the English, you're having to serve outside the jurisdiction, because you're doing that in a foreign state, the court requires, stipulates certain, and the rules stipulate certain requirements must be met. So, in every case in the DIFC, the subject matter, the scope, must come within the relevant articles that stipulate the jurisdiction. Together with the fact that there has been service. That's three.
Yes. Yes. I think the short point that I was making was, and the point in fact that you made to me, was the fact that in England one needs permission to serve out of the jurisdiction is what makes all the difference in that jurisdiction.
It's a crucial difference between the English arrangements and the DIFC. No such permission need be sought. But the rules say you must comply with local requirements when you are serving in a foreign state.
Yes. Yes, absolutely. But the upshot of that is that there's no room, and Your Honour found that there's no room to introduce any kind of merits threshold.
No merits threshold.
Yes, quite. So that's why. Yes. Yes. All that's required, and this was following the decision in Hart and Dambank, is that a case is articulated, and against that party, if it's that, or that fits the description.
In other respects, utterly untenable, then the court will ensure that this process is not abused. Now, whether that's to be characterised as jurisdiction or to be characterised as a court protecting its jurisdiction, preserving its jurisdiction for proper and fit cases, that's neither here nor there.
It has the capacity to do that with applications of this sort. It is needed.
It has that. And they need to have the label of jurisdiction.
Yes. As I say, for the purposes of today, we need to deal with these applications, and tomorrow we need to deal with these issues anyway that are raised, and we have a difference about which box they go into. But they could make a difference to the way that the case is decided. That's all we're saying. So it's 4:30. I don't know whether you want to. Yes, I'm grateful. Certainly. So the 3 points. they're expressed as 3 points, but they merge together. 3 points that are made are this, that the New York judgment is not a judgment, it's not on the merits, and it's not final and conclusive. Your Honour was shown some authority today, and in particular on the question of judgments and final and conclusive, the story rather ended in the 19th century. The story of the common law on this is not ended in the 19th century. The fact, though, is that by the implementation of multilateral treaties for the enforcement of judgments, rather like forum non-conveniens, the number of cases in which these sorts of issues has arisen has not increased in the same way that other areas of commercial law have increased. So we do need to look back to some extent at some of the older cases, and I would suggest, and this is reflected in the commentary as well, it's certainly appropriate in this field, even for the English courts, to look outside their own borders to the other Commonwealth countries, to look at the decisions and the ways in which things have been decided there, to get a better sense of what is really meant by cases like Nouvion. I accept that on one reading of Nouvion, it rather looks like if you can show that you can come back to the same court on any basis and reopen the judgment, then that's not final and conclusive. That seems to be, on one reading of it, that's what my learned friend says, if you read it literally like a statute, that's what it's saying. And in fact, if you look at the way that the commentary deals with that case, if you look at the way that other cases deal with that case, in fact, where we've got to on this is the distinctions between whether or not it is a provisional judgment, which in the ordinary course can be reopened, or whether or not it is final and conclusive unless and until it is set aside. And that's the distinction. And it's very clear in the cases, and there's I'm afraid I'll take you on through one or two of those cases if I may, and I hope to answer some of the technical points which are made to support what is really a very unmeritorious position. In fact, happily, the case was developed in a way which does support the meritorious position. The first point then is that there's no judgment, and Your Honour makes the point, well, the defendant actually consented to this and agreed to a procedure pursuant to which it would be a judgment, would be treated as
it is a judgment being issued by your state court as a judgment.
Yes. Yes.
The argument is really, well, all right, it may be a judgment in that instance, but it doesn't qualify for...
Yes. So what I need to show you, Honour, is really one passage from Dicey and one case, if I may. So the passage from Dicey is my learned friend's authorities bundle. It's the second one. So the defendant's second authorities bundle tab. Is it? Yes, it is. Tab 20. And I'm afraid there's not much in Dicey on this. I suspect because it doesn't come up much. Page 673. 673. And all it says, so we see in Rule 42, the requirements for enforcement of a judgment. Subject to the exceptions hereinafter mentioned, and to Rule 62, a foreign judgment in personam given by a court of foreign country under jurisdiction, blah, 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 in accordance with the principles set for jurisdiction, not impeachable under any of the rules, may be enforced by a claim or counterclaim from out if it is for debt and so on, and if it is final and conclusive. And then it's really only footnote 73, which helps us in Dicey, which says, as to what is a judgment, see Berliner Industry Bank and Jost, ascertainment of a debt in German bankruptcy proceedings, and there's some various other. So there just isn't much guidance there. The only reason I take you to that is to show you that the case that I'm going to direct you to is in fact the case that Dicey directs us all to on this particular question, not the Inri Moore case that my learned friend took you on to. I'll go back to Inri Moore in a moment, if I may, but just first dealing with the Berliner Industry Bank and Jost, which you'll find in my authorities bundle, is at the back of the second volume, tab 42. So the background is explained. I won't ask Your Honour to read it, I'm going to summarise it if I may. But just for your note, Your Honour's note, it's at page 466G to 467B, just in case there's any background. But essentially what had happened was that there had been some German bankruptcy proceedings. And so the creditors had submitted proofs of debt. And what happens in those proceedings is the judge creates a table and enters those entries into the table. And the hope is that the debts will be met, the debts in that table will be met from the existing assets of the bankrupt. And then the trustee takes all of the existing assets. And he tries to, and then he discharges those assets up to the value of the debts. And as I said, hope. I don't know. I don't know precisely what the rules are. I assume so. Subject to any security, I presume.
Subject to liability
what happens once the bankruptcy ends? If there are any outstanding debts from that table, the creditors are then entitled to go after any assets that the bankrupt has accrued since the date of the bankruptcy. And then what happened in this case is the bankrupt, in the interim, moved to England. And so the creditor had this table which had been produced by the judge, and he sought to sue the former German bankrupt who moved to England, in England, on that judgment. And so one of the points that was raised in the case was that this was not a judgment. And so what mattered, and this is the important bit, what mattered was the treatment of that instrument in German law, and that it was treated as a judgment in the right circumstances. You see that at 469B, down to G. Would you want to prefer to read that?
Yes,
I'm quite happy with you, but thank you. So you will have seen that, firstly, one of the points taken was precisely the point that my learned friend makes, which is that what was said in this case was, well, if the provisions of the law have deeming provisions in them, saying this instrument is deemed to be a judgment, well, that indicates that absent those provisions, it wouldn't be a judgment. And effectively, the way that the Court of Appeal dealt with it is about, it's on 469D, just by looking at the treatment in German law. So it's saying, as between the creditors, the fact that it's in that table is binding between the creditors. But if the bankrupt doesn't object to the entry in the table, then once it's been entered by the court, that's it, it's treated as a judgment. And that was sufficient to permit the enforcement of that debt in England. So this goes to a number of different points, principally to the point of what is a judgment, but it also goes to the point of whether or not a judgment by consent, for example, or a judgment by default, may be enforced as a matter of English law. There was no argument in this case put forward by the debtor, the bankrupt, to say, well, that wasn't owed, that was owed. There was no judicial mind applied to the question of whether or not in a particular case the debt was due. It simply was recorded an instrument, it was a judgment, and therefore it was enforced.
Yeah.
So this is a case from, I believe, 1971. So we're quite a long way through the development here of the common law on these issues. But in this case, in our case, the effect of the New York judgment is not in doubt because it's stated in the rule. Rule 3128B simply says that it will have the same effect as a judgment of the New York Supreme Court. So we're very much in the same territory as this case on that question. Now, my learned friend relies on the Faithful case, in re Moore on Faithful. The point to be made, there's a number of points to be made about that decision, and I can take you on back to it if it helps, but just to make the submissions. It's found that defendants' authority fund tab 4 if needs be. The question there was whether a costs order was a judgment in that case for the purposes of English bankruptcy legislation. And the point that was made against that, what had happened, was that the court had found on liability, and then the damages part was not pursued. So the court had made a finding on liability and made an order for costs, and then the claimant had not pursued the second part of the action. So there was no final judgment on content. And so the argument that was being made was that the judgment was not final and conclusive because there was more to happen, there was more to come. And that hadn't happened yet, and that the costs order didn't establish a pre-existing liability between the parties and therefore wasn't enforceable. And the Court of Appeal made quick work of that, and that's why they expressed their views in terms of all that is required is. And it's in that context that I think it was Lord Justice Cotton said it has to be on an action. Now, effectively what my learned friend does is he takes that word action and he treats it like some sort of statutory requirement. Because Lord Justice Cotton says there needs to be a determination following an action of a lease, etc. But he focuses on that word action and says, well, there's a particular type of action and this doesn't fit within what is required as an action. What has happened in New York doesn't count as an action for the purposes of Lord Justice Cotton's definition. But the court just wasn't dealing with this sort of question. It didn't have in mind the different ways in which a foreign court might find its way from some sort of claim to a judgment. But I think what I would suggest is necessary is simply, well, firstly, does this judgment by judicial means establish the existence of a pre-existing liability? That's effectively what is meant, what is being got at in the Remore Faithful case. It's not really about the process of getting towards that. And in this case, it clearly is, because you can see it in the confession, because the confession itself says that the defendant admits the existence of the liability arising under the guarantee and submits to judgment in effect by consent. So there's two parts, effectively, to what my learned friend is saying, it seems to me. One is that you can't enforce a judgment by consent. He says that in terms. That's wrong. It's a matter of law. And then the second part, it seems to be, is that the process by which you obtain, in this case, a judgment on a confession somehow doesn't count. It's not sufficiently an action for the purposes of enforcement. That's effectively, it seems to me, what he's getting at here. The issues rather merge with the question of on the merits, the question of final and conclusive, but I'll just deal first with the question of whether or not a judgment by consent is enforceable. If I may, I should show you that you've drawn up some authority on that, if I could. The first place to look is, my learned friend's second authority bundle back in Dicey. It's page 683. 683. And 14-037. So we're rather overlapping here with the question of on the merits. And I'll come back to on the merits if I can in a moment. My learned friend says the judgment by confession can't be on the merits. So we have Dicey, paragraph 14037.
Yes.
Final sentence. A judgment in default or by consent may, however, be a judgment on the merits.
Footnote 153.
Yeah. I don't have the authorities that are referred to there, but I do have some other authority which I can show you on right now. But it's going to go. You're going to have to go back to my authorities bundle, and it's tab 21, which will be in the second bundle. The reason it's not dealt with in my submission in great detail, rather like the question of judgment, is that it's really controversial. So tab 21 is the South American Mexican Company ex parte Bank of England. So you want to have that?
Yeah, I've got that.
And again, I won't read out vast tracts of this, but Your Honour can pick up the thrust of it from the headnote. The judgment by consent or default is as effective as an estoppel between the parties as a judgment, whereby the court exercises its mind in a contested case. So what had happened here was that there had been a claim on a debt by one party against the defendant. The defendant had denied the existence of the agreement which established the debt. The case had been started and then had been settled, and a judgment had been entered. And so, and then what had happened is that the defendant's liquidators, in another claim by the Bank of England, tried to run the same argument that the agreement didn't exist. So it was an issue of stop position. And the answer, if we go forward to page 44, it goes back to your Honour's point that we need to maintain a degree of common sense rather than treating these 19th century cases as statutes. Mr. Justice Vaughan Williams, Chancellor, I am of the opinion that my decision must be in favour of the Bank of England and against the official receiver. My only reason for hesitating to come to such a decision has been that I could see so little ground for doubting the matter that I was afraid I must be overlooking something. Two questions arise, and then I'll let Your Honour read the rest of that. If Your Honour reads down to the following page, about halfway down, and finally, if we go forward to tab 24, just because we're doing a bit of a root and branch exercise here, I'm afraid. And it's the case called Naraji, and if we simply turn forward to page 126, paragraph 126, I'm afraid the page is not paginated. Paragraph 126. As to whether a judgment is final and conclusive on the merits, it has long been recognised that a judgment disposing of the case by consent is just as capable of being final and conclusive on the merits as one given following the determination of disputed issues. Now, these were, and this is an important distinction, these are cases about issue estoppel. And so, and this is where it can get a bit mixed up, because when one starts to consider whether or not there is an on the merits requirement for enforcement, one can see that the requirement that it be on the merits is different, or could be different, depending on what you're doing. If you're enforcing a judgment, that's one thing. You're enforcing a debt created by consent, by participation, by presence in the other country, and then a judgment being issued. That's all you're doing on the one hand. On the other hand, if you're trying to examine that judgment to determine what issues were determined by it, what issues were decided, and therefore what issues can't be run subsequently in another case, then one can see it becomes much more difficult if the case is by consent, the judgment's by consent, or if it's by default. It can be very difficult to extract, and there's multiple warnings in the authorities about how dangerous it is to, particularly where you're dealing with foreign courts, where judgments are by default, to try to work out what was being decided by that judgment. In fact, the English courts, until some way into the 20th century, did not recognise an issue of estoppel created by a foreign judgment at all. And so these two strands developed rather separately. So there's always going to be a note of warning, a health warning, associated with looking at cases on issue of estoppel and then interpreting them and applying them to cases that are dealing with the enforcement of foreign judgments. I will develop that the way that has happened in the Commonwealth authorities. There's one authority in particular from Australia which does go through in quite a lot of detail. I think it's the Federal Court of Australia, but it's one of the ones that's regularly cited, and it's helpful. What I may do, rather than take your honour through that in detail, is perhaps direct your honour to those passages and ask your honour to perhaps just read those bits overnight, and then we can resume tomorrow.
I think if you could wrap up 2 or 3 minutes of today's proceedings.
Your honour, yes.
And then we'll be going again tomorrow at 10 o'clock.
So, the submission that you can't enforce a judgment by consent or a default judgment is simply wrong. And then the next question is, well, is there some problem with the mechanism by which this judgment was obtained? It's a short-form mechanism for getting from an agreed position to an enforceable instrument in the form of a judgment. It clearly engages the procedure of the court. We can see to some extent what was done. So what happens is a party files an affirmation, is what happened. I'll give you one of the reference that I won't take you on to. It's 2B, page 490. What happens is that the court then affixes a number to the top right-hand corner, and then there is clearly, albeit not by a judge, but by a court officer, court clerk, a consideration of what has been submitted, and then a judgment is issued. It's not simply mechanistic, and we can see that in this case, because the numbers have actually been amended. There was an entry for the cost of the transcript, which was deleted. It didn't make much difference, but it does show that somebody's applying their minds towards this and making sure that the relevant test is being applied, and then a judgment comes out at the end. So what is the difference between that and obtaining a default judgment in, for example, this court or in the English court? You don't even need to make an application in most of those cases. The only difference is you don't have a claim form that's been issued in the first case. And service can't be the answer. It can't be right that we just don't enforce that there's some problem with obtaining judgment before it's been served, because we can get judgments before they're served when we're enforcing, for example, international arbitration. This is one example of that. But why is it that the process which the parties have agreed should be adopted, for the very purpose of making it easier for my clients to get to a judgment, why is it that should make any difference at all to the enforceability of that instrument? And the other point on this, sort of, should we ever enforce this sort of judgment, the result of my learned friend's argument is that my client's rights under the guarantee are, as a matter of New York law, reduced into that New York judgment, but I can't take that anywhere else. So actually, my clients are shocked.
But you can't take it to any common law jurisdiction who would have taken an approach to all motives by English law.
Yes.
Is that right?
Yes. But we would have taken a large step back from being owed.
Yeah.
Yes.
Well, is that what we
Yes. John, it is.
Can you remind me where the participating agreement is? I'm not looking at that overnight.
Yes. So you'll find the participation agreement is bundle 2B. Page 419. Yes, that's right. And the representation agreement, if that's helpful, is at 456.
Thank you very much.
Your Honour, if it is helpful on the issues of final and conclusive on the merits, it's the case I was referring to is the case of Schnabel. It's in fact a decision of the Supreme Court of New South Wales.
Where is that?
It's in my authorities bundle 2, tab 35. And there is a long discussion which extracts various relevant parts from a lot of the different cases that have followed Moving in particular.
Now, which volume of advisory, volume 1 or 2, do we get the recognition and enforcement of?
Volume 1, chapter 14. But it is also, almost all of the relevant passages are in my learned friend's authorities bundle.
Well,
Grateful.